Hello and welcome to Media Law and Ethics revision class. Last time we were discussing about the elements of breach of confidence. Today we are going to progress on from where we stopped, and we are going to discuss about the defenses of breach of confidence. For example, let's say you as a journalist, despite the fact that you have exercised all the precaution in order to prevent infringing into other people's privacy, someone happened to in the court of law for breach of confidence, or else for infringing into his personal property, or else for violating his personal rights. How are you going to defend yourself in the court of law? Or is what are you going to do in order to defend yourself in the court of law? So you have some of the most common defenses that are normally used in the court of law against the law of breach of confidence. And we are just going to discuss 4 of them that you can use if you happen to sue in the court of law for violating someone's privacy, or else for infringing into someone's confidential data or confidential information. And one of the main defenses we normally use as journalists against the law of breach of confidence is what we call public domain. Under public domain, this defense extrapolates or explains about information that is already in the public, or else information that is already in the public domain. So it means most members of the public are aware of what is happening, whereas most members of the public are already aware of what has been taking place concerning that particular information. For example, let's say a certain politician has engaged in criminal activities. Many people know about what has happened. There's no way he can be able to sue in the court of law for violating his privacy, or else for infringing into his personal property. So now using public domain as a defense, this is whereby you as a journalist have to justify before the court of law, or else for the judges that indeed the information we are talking about, the information you had disseminated, or the story you wrote about, it was already in the minds of the public. It was already in the domain. Domain means many people are aware about it. For example, maybe the information had circulated through social media, whereas other newspaper had already carried the story, whereas other radio station already carried the story. So you are not the first person to write that particular story, but this information was already in the public domain, whereas many people already aware of what was happening. You are just trying to give your own opinion about what had already transpired, or what had already happened. So public domain is one of the main defenses normally used against the law of breach of confidence. We are saying that you have to justify before the court of law that the information we are talking about was already in the mind of the public. Then how about is called other defense, what we call the consent. Now consent simply means the owner permitted the publication. Before you disseminated the information, before you happen to publish the information, the owner of that particular information gave you the go-ahead. He gave you a consent, or else he gave you a permission to go and write about his story. For example, let's say someone happened to give you a go-ahead, write his profile, or else write something about his company, or else his organization. And as long as happened again to sue in the court of law for infringing into his personal rights, or else for violating the law of confidentiality. You are going to use consent as a defense because the owner himself gave you the consent, or else gave you the permission to go ahead and publish that particular story. So in most cases, we are happening, maybe let's write about a very sensitive matter, or else you're writing about a very secretive information. It is advisable as a journalist to always seek for permission from the owner, or to seek for permission from the concerned parties. If they are against the story, and maybe they happen to violate the law of breach of confidence, then you as a journalist can use what is called public interest as a defense. So if someone happened to give you a go-ahead, you can go ahead and carry a story. But now let's say again he happened to sue in the court of law, despite the fact that they gave you the go-ahead, write about his article, write about his personal life, write about his company, and he happened again to sue in the court of law, you are going to use consent as a defense against the law of breach of confidence. Then how about it's called the defense of iniquity. And the defense of iniquity, iniquity simply means an evil act, or else an act that is wicked in the society. So if you wrote a story about an iniquity, an information that was exposing an illegal activity in the society, or else an information that was exposing a wickedness in the society, or an information that is exposing an evil act in the society, then you can use iniquity as a defense against the breach of confidence. For example, let's say you happen to expose information about a specific company that is offering illegal drugs, or a specific organization that has engaged in corruption activity, We are going to use iniquity as a defense because you are exposing an evil act, or else you are exposing a wickedness in the society. So iniquity is a defense whereby it's normally used when you as a journalist wrote a story that was exposing an evil act in the society. So even if someone happened to see the court of law, you say that the reason why I wrote this particular story, or the reason why I came up with this particular article is because I wanted to expose an evil activity in the society. I wanted to expose a wickedness in the society. I wanted to expose an iniquity in the society. That's why it is called iniquity as a defense against the law of breach of confidence. Then you have what is called public interest. These are general defense that applies not only to breach of confidence. This defense applies to law of contempt. It applies to law of copyright. It still applies to law of privacy or privacy law. So under this particular defense of public interest, this whereby the reason why you came up with a particular article is because many people wanted to know what was transpiring. Many people wanted to know what is happening. For example, in Kenya today we are talking about what is happening at KEMSA. There are some illegal activities or corruption activities that are taking place at KEMSA. So you as a journalist can go and write about that particular story, and when someone happened to see in the court of law, you say that the reason why I wrote about this particular story, it was because it was a matter of public interest. This means many people wanted to know about what was happening, and this story was affecting many people in the society. For example, let's say it is affecting what is happening now, and it's likely to affect what is going to happen in the future. So public interest is a common defense that is normally used by journalists to come to defend themselves if indeed the story they are talking about, or the article they are talking about, is trying to expose an evil act or an activity that is affecting many members of the public or many members of the society. So these are the four main defenses you can use under the law of breach of confidence. We say that public domain, whereby the information is already in the minds of the public. We have discussed about the consent, and this one means the owner gave the permission to publish the story. And we are talking about iniquity, whereby you are exposing an evil act or an evil activity in the society. And last but not least, we have said the defense of public interest. This one means the story affects many people in the society, and they want to know what has transpired, what is happening, or what is likely to happen in the future. Thank you for your time. I hope you will be able to apply these defenses in your real life situation and even in your exam. Let's meet next time at the same place.